Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and today we're continuing our series of videos on the H-1B visa classification, talking about the H-1B amendment and extension classifications. An H-1B amended petition is required when there is a material change in the terms and conditions of employment. That can include, but is not limited to, a change in the person's job duties, their job title, their salary, going from part-time to full-time, or a change in their worksite location. If you have a question about whether an H-1B amendment is required due to a change in your H-1B employee's employment situation, be sure to speak with your immigration attorney to make sure that you have all the information to make the correct assessment. The H-1B amended petition has to be filed before whatever change that's requiring the amendment takes place. The H-1B extension, as the name implies, is an extension of an H-1B employee's H-1B status. It's possible to hold H-1B status for up to 6 years, and remember that we can request up to 3 years of status at a time. So the process of filing an extension is simply asking USCIS, I say simply, but it's a whole filing, asking USCIS to extend that person's H-1B status. If the H-1B extension is timely filed, meaning before their current H-1B status ends, and if the person is working in valid H-1B status, then the H-1B employee can continue working beyond the expiration of their I-94, meaning beyond the expiration of their current H-1B validity period, for a period of up to 240 days beyond the expiration of their current status. So it's not required that it be approved before the end of their current validity period. It is possible to file an H-1B amendment and extension at the same time. Likewise, it's possible to file an H-1B transfer, which we talked about in our previous video, and extension at the same time. Finally, know that it's possible to request an extension of H-1B status beyond the 6th year. I know I just said there's a 6-year limit, and that's true, but there's an exception to the rule. If the H-1B employee is at a certain point in the employment-based green card process, it's possible for that particular person to extend the H-1B status beyond the 6th year. In particular, that means that if the H-1B employee has filed the PERM labor certification, or rather if their employer has filed the PERM labor certification at least 365 days before the end of the 6th year, then the H-1B employee can request a 1-year extension multiple times, but they can request an extension beyond the 6th year in 1-year increments. Likewise, if the H-1B employee has an approved I-140 petition, then that particular individual can request extensions beyond the 6th year in 3-year increments, again, multiple times. But it is required to have the I-140 petition approved to request 3-year increments. We'll be talking in subsequent videos about what these terms mean, the PERM and the I-140. Know that when you file an amended petition or an extension petition, you are filing an entire petition with USCIS. So you have to have the LCA, all of the required forms, all of the required supporting documents, and the required fees. Our next video will be on the exciting topic of concurrent H-1B and CAP exempt employers or institutions. If you have not already subscribed to our channel, I hope that you will do that so you won't miss our next videos. And until next time, I'm Emily Sumner.